not apply to section 4 of this notification. If your lordship may kindly see section 4. Sir, आपको मिल गई sir?
जी 149 मखदूम साहब की कौन सी पेज पे?
Sir, मेरा CMA है sir 6. It's the last
page.
Last annexure.
रीडिंग नोटिफिकेशन हाँ वही है
जी
जो इस किताब में भी है.
जी I didn't know that. I'm sorry.
ठीक.
Sir, section 4 अगर मैं पढ़ दूं.
ये इस किताब में भी है at page 149.
Sir, if I may read.
वाली कुछ और है 151 पे.
जी section 4 sir.
पढ़ें.
Substitution of section 232 Act of so and so of 2017. In the said act, for section 232, the following shall be substituted. Now this is critical. And shall, notwithstanding anything contained in subsection 3 of section 1 of the said act. Now subsection 3 of section 1 of the said act, which is the election act, it says that the election act will come into force.
We're not with you, just a second.
Sir,
हमें नहीं मिल रहा वो.
Sir, अगर फिर अब वो आप CMA देख लें please.
Page 40 of the CMA.
152 पे 151 पे
एक सेकंड 152.
चलिए ठीक आप पढ़िए
जी
सबसेक्शन 4 पढ़िए और सेक्शन 4.
In the said act.
Said act is Elections Act.
And if your lordship looks at subsection 3 of section 4, it says that the election act will come into force at once. But it says, shall, notwithstanding anything contained in subsection 3 of section 1 of the said act, always be deemed to have been so substituted on or from the commencement of the constitutional 18th Amendment Act of 2010. Namely, I stop here. Very critical that Parliament, while enacting this law, has put in this deeming clause and made this amendment retrospective from the date of the 18th Amendment. Now, the 18th Amendment is where those phrase, court of law, declaration, court of law comes in. So it is made applicable from that day. Now, I'll move forward. Now, what is the amendment itself? The text of the amendment is very important. Qualification and disqualification. The qualifications and disqualification of a person to be elected, chosen or to remain as a member of the Majlis-e-Shura Parliament or a provincial assembly shall be such as provided for in Articles 62 and 63 of the Constitution, provided that the procedure, manner, and duration of the qualifications and disqualifications under this section shall be such as specifically provided for in the relevant provisions of Article 62 and 63 of the Constitution, and where no such procedure, manner, or duration has been provided for therein, the provisions of this Act shall apply. Critical. There are three things for which Parliament is legislature on, and this is critically linked with the question of court of law. Procedure, manner, and duration. Samiullah Baloch only covers duration, but let us move forward and come to subsection 2. Am I with your lordship? Subsection 2. Now, again a notwithstanding clause. Your lordship said the amendment began with a notwithstanding clause and a deeming clause. Again a notwithstanding clause. Notwithstanding anything contained in any other provision of this Act or any other law for the time being in force, and judgment, order, or decree of any court, including the Supreme Court and a High Court, the disqualification of a person to be elected, chosen, or to remain as a member of the Majlis-e-Shura Parliament or a provincial assembly under paragraph F of clause 1 of Article 62 of the Constitution. I'll stop here. Only mentions a specific article, not the entire Article 62, doesn't mention D and E, it only mentions F. Of the Constitution shall be for a period. Now it's not 5 years, it says not exceeding 5 years. So a kind of discretion is left.
Up to 5 years.
Up to, not exceeding 5 years from the declaration by a court of law in this regard. Very different even from 63 time periods. Very different from, of course, Samiullah Baloch.
Mr. Faisal, for myself,
Ji.
this act came into force in 2017.
Yes.
What is the purpose of enacting from 2010?
Then मैं उसी पे आ रहा हूँ. मैं बस 2 लाइनें पढ़ दूँ and then I'll come to that. So a discretion is left from the declaration by the court of law in that regard. अब ये भी बड़ी important lines हैं जिस पे मैं dwell नहीं करूँगा, but important lines. And such declaration shall be subject to the due process of law. This is critically important to understanding what a court of law will mean. There is a specific provision with reference to 10A, due process have been incorporated. Now, a bare reading, and this is to your lordship's question, a bare reading of this act shows that the purpose of bringing this act is to override Samiullah Baloch. There can be no other purpose, but this otherwise, this deeming clause, this notwithstanding clause, this reference to the Supreme Court judgment, this only reference to Article 62 1F and not to the entire ambit of 62 and 1F would not be there. So, the intention of Parliament, as well as there is no escaping the fact that Parliament was of the view that Samiullah Baloch has to be overruled, and this is how we overruled. And what Parliament had in mind, because it doesn't, here really Parliament doesn't specify the court of law, procedure, other. It focuses on duration. It's left the other 2 elements for the future to be specified, unless they are specified in 63. But when it comes to time period, it specifies the time period. So, my lord, the primary submission which I will make before your lordship is that in terms of the intention of Parliament as well as in terms of the text of this law, the text of the law along with Samiullah Baloch, only one will survive. So 232 would be correct law if Samiullah Baloch is overruled by your lordship. But if Samiullah Baloch is there, then this section, to the extent of the time frame, not the entire law, but to the extent of the time frame, would be in violation of the Samiullah Baloch judgment. This would be my primary submission before your lordship. And the reason I would be submitting before your lordship that your lordship must overrule Samiullah Baloch is because I think it poses numerous problems as far as constitutional interpretation is concerned, as well as the democratic.
But if this law overrules Samiullah Baloch, then why do we have to overrule Samiullah
My lord,
Baloch?
a statutory law cannot overrule a constitutional interpretation of a judgment, as my learned friends have repeatedly submitted before your lordship.
Can you repeat that? Statutory?
Basic judgment is for
Statutory law?
A statutory law, my lord, cannot override a judgment of the Supreme Court which explains, interprets a provision of the Constitution. These notwithstanding clauses, my lord, as it has been well understood, can only override judgments which are based not on constitutional law, but on non-constitutional law, sub-constitutional law, if they get rid of the basis of that judgment. So, as I was submitting, my lord, it's important.
Just section 4 of the notification.
Ji.
But this effect of from 18 amendment that has not been actually incorporated in the section 232 of the.
It is, but it is the the amendment has been brought through this notification, so the amendment would be read with the opening thing.
Section 232, it's itself under the statute that has been amended. If you will read that, it is not giving effect from
Sir,
18th Amendment.
So these amendments never incorporate.
The scheme and policy of the law, but what is the actually amended law is there, which is in the statute book.
No, my lord, this is a very common practice that when an amendment is brought in, its effect is never incorporated in the provision itself. It's always in the opening portions of the law. There are numerous examples of that.
Okay, if you will read 232, they are not giving this effect from 18th Amendment. That is why the retrospective effect does not mean.
My lord, they have. If your lordship may kindly read it again, it says.
Section 232 only.
No. But 232 has been brought in through section 4, my lord.
Section 4, so why the legislature has not mentioned the effect from 18th Amendment?
Because it is never mentioned. Sir, ये कभी नहीं होता. आप कोई भी amending law देखेंगे, amending law की opening provisions mention करती हैं, वो कब से आएंगे? कुछ amendments होती हैं जो incorporate करती हैं. लेकिन sir, if we leave that debate, जो subsection 2 है, it makes it
बाद वो laws में सारे जो
जी subsection 2 है, it makes it obvious what ठीक है sir. अब
उसका judgment के ऊपर आता है.
जी now, as I said, why is Samiullah Baloch a problem in terms of constitutional interpretation, as well as really, I would say, very problematic in terms of democratic growth in this country, my lord? It's important.
Mr. Faisal, we've read this 232 clearly with you for the first time in detail. Now the question is, could a sub-constitutional amendment like this control the scope of the constitutional amendment? Had it been that the period of that declaration is 5 years, that's a separate thing. I was under the impression that declaration is for a period of 5 years. Here it is that disqualification of the person under 62(1)(f) is for 5 years.
Yes.
Now that is regulating or controlling a constitutional provision.
Yes.
They could have said that the declaration under the which is being adopted under 62(1)(f), such a declaration which is passed under the law could be for 5 years. That's a different thing.
Yes.
But they seem to have gone over that.
Yes.
And so that's directly inconsistent with the Constitution. So how can the sub-constitutional legislation start
No,
controlling?
it cannot. So one of the things which has not happened, एक तो ये नहीं पढ़ी गई थी इसलिए मैं पढ़ना. Sir, there is no doubt one of these two things will stand. The legislature has no doubt about that in order for this time limit to be imposed, Samiullah Baloch is an obstacle. Now, it's important, sir, कि Samiullah Baloch को कि कुछ passages पढ़े जाएं. It's very important because I think that is also quite a misunderstood judgment. Sir, if your lordship may kindly look at PLT 2018, Supreme Court 405.
आपका कंटेंशन ये कि कॉन्स्टिट्यूशन के प्रोविजन को एक ऑर्डिनरी लेजिस्लेशन जो है वो टाइम फ्रेम दे सकता है.
Sir,
aren't you reading into the constitution?
नहीं, मैं ये नहीं कह रहा. मैं ये कह रहा हूँ a constitutional provision which has been interpreted.
Suppose there was no interpretation.
Yes.
There was no
Yes.
और ये law आ जाता.
Yes.
तो फिर आप उसके बारे में बताएं.
I think a law not only could have been brought, but it was absolutely necessary to execute that provision. That is what I would be submitting.
Mr. Faisal, as following that question, suppose there is no Samiullah and there is this confusion about the time frame in 62(1)(f). Parliament, through an act of Parliament, cannot start regulating and controlling the meaning of the constitutional provisions. They could have only done it through a constitutional amendment.
No, my lord.
The only margin, speaking for myself, could have been, because in 62(1)(f) I see that the declaration is coming from some other source. That declaration could have been time bound through a law, but not the actual disqualification under 62(1)(f).
Sir, let us leave that debate about that distinction. What I would be submitting after I read Samiullah Baloch. What I would be submitting before your lordship is that this is a case, और ये Justice Mandokhel ने बार-बार ये बात कही थी. This is a case of the doctrine of constitutional absences, of what is called the doctrine of constitutional abeyances. This is a well-recognized doctrine, which is that when a constitution leaves things without determination, how is the court to interpret that?
To make the provision executable.
जी?
Article 62 में ये 232 आप कहते हैं कि to make that provision executable.
क्योंकि कॉन्स्टिट्यूशन ने जानबूझ के सर टाइम फ्रेम नहीं रखा है. Now what Samiullah Baloch has done is that it had seen this as an invitation to fill the gap and put in a permanent disqualification. No, constitutional absences are not to be fulfilled in that term, because constitutional absences then follow up with another well-recognized doctrine of constitutional law, which is constitutional implications, that provisions are interpreted in terms of its implications. And one of the fundamental principles of constitutional implication, the doctrine of constitutional implication, is that gaps have to be filled by looking at other provisions of the constitution.
So, but ठीक हो गया, फिर legislation को छोड़ दें, we simply looking at interpretation of the constitution.
Ab Samiullah Baloch. What does Samiullah Baloch do? Sir, it's important, if your lordship may kindly see page 412.
So वो जो argument है कि causes omissus है and parliament fills the causes omissus, you're basically saying we should fill it.
That is what Samiullah Baloch does, that it fills it.
Can't do it.
And it fills it in a way which is a violation, I think, of the doctrine of constitutional absence. जब आप फिल करते हैं गैप, आपको पहले सोचना चाहिए कि ये पार्लियामेंट ने क्यों एब्सेंस छोड़ी है. Samiullah Baloch fills in the gap in a way that there is nothing left for parliament to do. That is the problem which Samiullah Baloch does. लेकिन मैं पहले Samiullah Baloch.
पढ़ लें, because we need to know what the constitutional absence is.
If your lordship may kindly see 412.
जी.
सर अगर मैं 411 से ही पढ़ दूं लास्ट लाइन से. The crucial question raised is whether the incapacity imposed, if your lordship have it, imposed by Article 62(1)(f) of the Constitution upon a person interested to contest an election to a seat in the National Assembly or Senate is of perpetual effect if there is a declaration against him by a court of law to the effect that he lacks sanctity or righteousness, or is profligate, or is dishonest, or is not a mean. The question is posed because Article 62(1)(f) of the Constitution does not stipulate the duration of incapacitation of a judgment debtor upon a judicial declaration. I'll stop here. This is an exact definition of what is called constitutional absences or constitutional abeyance.
Where do you draw this doctrine from?
Sir, मैं अभी cite करता हूँ. It's a well-recognized, इस पे जो सबसे famous किताब है is by Michael Foley, The Doctrine of Constitutional, but it's been applied by courts. If your lordship may kindly see page 436.
(436)?
जी sir. Above para 24, I read from the top 6th line. In the present context, the conditions and qualifications in Article 62(1)(f) of the Constitution were retained in toto and made objectively and transparently enforceable by the prescription of a judicial declaration for precipitating the loss of the electoral qualification specified in the said clause. where a declaration made by a court against a candidate for election warrants the conclusion of his misrepresentation, dishonesty, breach of trust, fraud, cheating, lack of fiduciary duty, conflict of interest, deception, dishonest misappropriation, etc. to be derived from such a verdict. अब ये reasoning है कि क्यों fill in the gap हो रहा है. Then it stands to reason that the consequential incapacity imposed upon the candidate should last for as long as the declaration is in force. This result follows, अब ये भी बड़ी reason है, this follows as a rational consequence of the judicial declaration and from the lack of any time period of incapacity of the candidate being laid down in Article 62, 1F of the Constitution. In other words, if the declaration has attained finality, the embargo under Article 62, 1F of the Constitution acquires permanent effect. So, what is the reasoning behind the judgment? There are 3 or 4 very important aspects to this reasoning. First is, it is recognized that Constitution silent. There is a constitutional silence, constitutional abeyance. Now, how does the bench fulfill that? It applies what is called the theory of constitutional implication. What is the rational consequence of this silence? Now, the court was of the view that the only rational consequence, so जब मैं second opinion पढ़ूंगा अजमत सईद साहब का तो ये बहुत ही obvious हो जाता है that the only rational consequence which follows from the consequence is, and they use 2 different terms which are self-contradictory. First they say that this time period will last till the judicial declaration is in field. The second word they use is permanent. Now these are self-contradictory because not necessarily that the judicial declaration will be for life. But when you use the word permanent, then you are saying it is for life. The word life disqualification is actually not used. These self-contradictory terms are used. But let me strengthen. Ab, sir, zehen mein rakhiye. They have accepted that the Constitution is silent. They have drawn a rational consequence of that silence. What does that mean? That means, if you turn to the next page, 437, second line, 437. Therefore, the consequence of permanent nature, i.e. incapacity, following a final and binding decree of court of civil jurisdiction, now very important these words used, is the ordinary and lawful outcome of civil litigation. The learned bench was of the view that the only consequence which would follow as an ordinary or natural consequence is one of permanent disqualification. That is where the mistake is made, and I'll show. But let me just complete the reading of this judgment, because there is another contradiction in the judgment. If your lordship may kindly see page 442 of the judgment. सर अगर पैरा 32 आपके पास है उसमें कोई 10-12 लाइनें छोड़ के वर्ड शुरू होते हैं considering. If your lordship may see, it's about. Now your lordship has seen it is based that there is no intention. That is why we are drawing a consequence. Now what does the judgment say? Considering that the Constitution does not fix the period of incapacitation of such judgment, of such a judgment debtor, shows a clear intention, your lordship may mark this, that the lack of disqualification under Article 62, 1F should extend so long as the declaration of law envisaged in Article 1F remains in the field. If such declaration is final and binding, then the incapacity to contest election to any of the legislatures provided by the Constitution become permanent. Now, they've taken another leap. They accept that there is absence of intention. They say we will draw a consequence, then self-contradict themselves by saying there is a clear intention that the disqualification is permanent. Now, if your lordship may kindly see para 36, which is at page 444. In the result, we are inclined to hold.
इससे पहले भी ये 4 लाइनें पढ़
जी, जी।
judicial mechanism
जी
इसी पैरा 35 में
जी जी सर
judicial
जी जी
mechanism.
The judicial mechanism in Article 62 1F of the Constitution grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate themselves. Therefore, the permanent, now again the word permanent, जी, incapacity of a candidate for election under Article 1F of the Constitution is not an arbitrary, excessive, or unreasonable curtailment of his fundamental right under Article 17(2) of the Constitution. In the result, we are inclined to hold that the incapacity created for failing to meet the qualifications under Article 62 1F of the Constitution imposes a permanent bar, which remains in effect so long as the declaratory judgment supporting the conclusion of one of the delinquent kinds of conduct under Article 62 1F of the Constitution remains in effect. So there are two terms used. It continues till the declaration continues. If Samiullah Baloch had limited itself to that, maybe then there was a reconciliation. But the use of the word permanent creates.
वो तो क्लियर कर देते हैं ना कि परमानेंट वो यूज कर देते हैं लेकिन आगे कहते हैं it will remain till such time that the effect is.
Sir, लेकिन permanent bar, but that is why the latter case
अगर
law.
डिक्लेरेशन कोई है परमानेंट तो वो जब हो जाएगा ना सपोज के सिविल सूट आपका था फिर अपील हुई फिर वो फाइनलिटी अटेंड हो गई तो इफ द जजमेंट इज अटेन्स फाइनलिटी देन तो फिर वो परमानेंट हो गया ना ये
लेकिन
मतलब
सर यहाँ पे permanence then gives rise to the misconception in later case law where the word used is life. Whereas Samiullah, because of this contradiction, created this problem. But let me come to Azmat Saeed Saab's note, which is much more definitive on this. If your lordship may kindly see page 446, para 3, side marked P. Now he completely eliminates constitutional absence. P. It is clear and obvious that lack of qualification in terms of Article 62 1F of the Constitution is the effect of a declaration by a court of law to the contrary, which is the cause. The obvious, legal, and logical conclusion would be as long as the cause, the declaration of a court of law holds the field, its effect, the lack of qualification shall also prevail. Now this is very important. This appears to be the only possible interpretation of Article 62 1F of the Constitution. How can you say that? When you say that it is a constitutional silence, that the only possible interpretation of a constitutional silence is what the learned judge is of the view. And he is very, I would say, disparaging of people who might take another view. If your lordship may see the last line, when referring to another article, he says, no sane person could seriously urge to the contrary. Sir,
I hope you're not pleading insanity.
Sir, if this judgment stands, then I would be considered as one of those insane persons. Sir, page 447, para 8.
Paragraph 8.
Ji, sir.
So did they consider other avenues and then by virtue of deletion come to this or this?
Sir, he doesn't. He is not even considering absence. He says absence ka matlab hai कि there must be one obvious interpretation. That is not what constitutional absences mean.
Any judge who disagrees with this judgment would be insane and therefore not able to contest elections under Article 63.
Sir, एक और बात कहते हैं अगर आप
Or any counsel or amicus putting forward, canvassing the proposition would also fall in the same category.
Sir, I would gladly
Cautioning you, Mr. Siddiqui, you tread carefully.
I gladly plead that insanity. एक और warning देते हैं सर पैरा 10 में जरा देखिएगा.
अभी आप
448.
अच्छा 10 पे चले
448 सर.
ये आप हमें डरा रहे हैं क्या?
सर मैं क्या करूं, जज साहब ने जजमेंट डराने वाली लिखी है. None of the counsels who appeared before us confronted the elephant in the room, i.e. the obvious interpretation. He has no doubts. There is no silence. Of Article 62, 1F of the Constitution is that the lack of qualification to a member is the effect of declaration by a court of law, which is the cause and period of qualification would be coextensive with the period to the cause, i.e. declaration. Now, here comes the warning. None of the learned counsels refuted the aforesaid obvious interpretation, but only sidetracked the issue. So, my lord, anyone who doesn't agree is sidetracking the issue. Now, the problem, this is the problem which Samiullah Baloch creates. And that is why I say sustaining this judgment is very problematic in terms of how the Constitution is to be interpreted. Now, when the legislature leaves something to the imagination, there is a constitutional, sir, you're talking about people who have made over 100 amendments in the Constitution, in the 18th Amendment. There is a reason why these constitutional silences are left. And the reason why constitutional silences are left is because, number one, either it is a very touchy issue. That is why the legislature at a particular time doesn't want to take a certain position. And it wants to leave it indeterminate, because putting in a definitive answer in the Constitution would give it a permanent character. That is why constitutional absences, and I now refer.
No, but what's your answer to this constitutional absence?
एक मिनट में जरा अगर पढ़ दूं एक दो पैराग्राफ, मैं पहले जवाब दे देता हूं.
जवाब बता दें कि हमें जरा समझ आ जाए. आपके मुताबिक क्या ऑप्शंस थे?
एक मिनट दिखाइए. Sir, to me, when there is a constitutional absence, then that has to be fulfilled by always keeping in mind that there is no intention of the legislature, whether it's a lifelong ban or a 5-year ban or a 3-year ban. That's the first premise you make. The second premise you make is because you are engaging in judicial interpretation where there is no definitive answer.
No, why don't you use a third interpretation? When there is a constitutional absence or abeyance, the constitution makers intentionally open the field for legislation.
Yes, yes.
Not for constitutional interpretation.
Yes, and any judicial interpretation which is made
Which
of the-
can be changed from time to time.
Yes, sir, exactly. And any judicial
But you
interpretation.
started off by saying that 232 can't be sustained.
मैंने
जी.
कहा था Samiullah Baloch cannot be sustained.
Okay.
232 will be sustained.
ठीक.
And just building on what the Honorable Chief Justice has said, That is why the constitutional implication should be drawn from that absence should be such that it should be changeable in the future through statutory interpretation.
Open through legislation.
Yes.
No, so, I mean, without taking the cue from the Chief Justice, I mean, could you just tell us what you were saying earlier before this comment was
I
made?
was going to explain.
How would you think this constitutional absence should have been filled? He took the cue and he went on, but before that.
Sir, the solution to
He doesn't want you to agree with me.
To me, another obvious implication of this absence, it is so obvious, is that if there is a court, let us forget about that there is what kind of court should be, can a declaration, if there is a declaration, it should apply to the next election. I mean, how can you say, if there is no intention specified in an absence, that this is not one of the logical consequences? You don't even have to go into the time frame, whether you should borrow 5 years from 63 or 3 years from 63.
Let's just to little more focus. I'm more a practical person. Undoubtedly, you and Mr. Bandari are more sort of philosophical.
Yeah.
Does the Constitution prescribe the punishment for murder?
No. No.
The only provision is Article 9.
Yes, of course.
No
Treason.
person shall be deprived of life or liberty save in accordance with law.
I did.
तो वो उन्होंने specify कर दिया with law, तो Pakistan Penal Code आ गया. But are there other provisions where they leave it open? For instance, and it has been supplemented by subordinate legislation.
So it's such a well-established doctrine. मेरी जो problem है,
नहीं, अगर ये लफ्ज accordance with law नहीं होता उधर, ठीक है, तो that means there could not have been legislation.
Article 20.
Only the courts could have said it would be death or life imprisonment in Article 9.
जी.
I don't know, I'm just imagining things. Because
I wouldn't go that far, sir, but it clearly indicates that there is.
no, because they can certain permanences, the Constitution are the guiding lights, it fixes. Some may be a bright light, some may be a little diya, which you have room around it for the Parliament to step in and legislate
There
on.
are, if your lordship searches the Constitution for the word permanent, perpetual, perpetuity, life, your lordship will not find it.
हर change eventuality में फिर constitutional amendment required
Yes.
होती है.
Sir,
No,
ye-
Faisal, I have a question.
जी, sir.
First of all, you'll have to take us through this concept of constitutional absences through a text of any book which says
I'm
constitutional.
taking you
That's
to a
what-
judgment.
नहीं, उसके अलावा, where is it as a text?
Sir, उसी में वो text
किसी
mentioned.
judgment में खुद ही लिख दिया होगा.
नहीं.
Where is they borrowed it from what text?
Sir,
So
it
where
is-
is this
As
principle?
a Harvard graduate or a professor saying something.
Or maybe of any
for the
other.
short-
मैं ऐसे वैसे एक चीज पूछ रहा हूँ, वो तो आप बता दें हमें. So suppose if there is such a doctrine, the constitutional absence has to be filled through judicial engineering, as you say. So one engineering was done in Samiullah, and one straightforward answer was that a declaration will continue until such time that the declaration is set aside. Is a straightforward, quite simple interpretation of filling the absence. You say, no, there could be yet another one, which is that he is disqualified for that election, which I find out of the two to be slightly more difficult one. The more easy one is the one that the declaration holds for such a time. I mean, if you're filling the absences, the more straightforward filling of the absence would be that the declaration continues. अब आप उसके ऊपर आपकी जो carving है, आप
नहीं, मैं
कहते हैं
उस
कि-
पे, मैं क्यों कह रहा हूँ, मैं उस पे आता हूँ.
Where do we draw the line?
No,
I
no,
mean,
मैं
how do
उस
we-
पे भी आता हूँ.
Or is there a third option that please send it to the parliament, let the constitution be amended accordingly and sort that out? Why should we get into the business of filling the absences, and where do we take the concept of causes omissus? Please अपनी जरा doctrine तो पढ़
जी,
दें.
जी. Sir,
Where is this doctrine?
मैं फिर इन सवालों का जवाब
पहला
देता हूँ.
doctrine बता.
जी, जी. If your lordship may see, this is a very famous judgment of Manoj Narula, in which the petitioners also.
If you say so.
Huh?
If you say so.
No, this is- in which the petitioners also wanted the court to read a certain disqualification in a constitutional absence in the constitution, and the court refused. If your lordship may kindly see page 21, bottom पे लिखा हुआ है sir pages.
जी.
Now, मैं सिर्फ आपको बता देता हूं, इशू ये था कि criminalization of politics को रोकने के लिए the petitioners wanted the court to say that even if a charge has been framed in terms of a heinous offense, that person should not be appointed as a minister. Now, this discusses this doctrine of constitutional silence. Bottom of the page. Principle of constitutional silence or abeyance. The next principle that can be thought of is constitutional silence or silence of the constitutional or constitutional abeyance. The said principle is a progressive one and is applied as a recognized advanced constitutional practice, has been recognized by the court to fill up the gaps in respect of certain areas in the interest of justice and larger public interest. Liberalization of the concept of locus standi for the purpose of development of the public interest, to establish the rights of the have-nots or to prevent damages and protect environment is one such feature. If your lordship may come to para 50, para 49,
There's no reference to this principle.
Sir, apart from the aforesaid reasons, उन्होंने judgments भी refer किए, अब मैं text की बात कर रहा हूँ. The arguments by the apparent cannot be accepted in view of the well-known constitution.
Which paragraph are you reading?
Para 49, sir, page 22. Para 49.
Para 49 तो कोर्ट है.
Sir, मैं अगर पढ़ दूं, वो judgments में से quote किया जो judge.
Okay.
Of the well-known constitutional doctrine, namely the constitutional doctrine of silence, Michael Foley, in his thesis on the silence of it's the most famous book on constitutional silence, has argued that in a constitution, अब ये बड़ा important है sir, in a constitution, abeyances are valuable. Therefore, not in spite of their obscurity, but because of it. They are significant for the attitudes and approaches to the Constitution that they invoke, rather than the content or substance of the strictures. अगर मैं para 50
This means that the silences have an importance.
Yes.
And they should be left silent.
नहीं, ये नहीं है. Sir, para 50 देखिए. The learned author elaborated this concept further by saying that despite the absence of any documentary or material from these absences are real and are an integral part of any constitution. What remains unwritten and indeterminate can be just as much responsible for the operational character and restraining quality of a constitution as its more tangible and codified components. The question that is to be posed here is whether taking recourse to this doctrine for the purpose of advancing constitutional culture, ये बड़ा important लफ्ज है. Can a court read a disqualification to the already expressed disqualifications provided under the Constitution and the 1951 Act? This is their election. The answer has to be in the inevitable negative. For there are express provisions stating the disqualification and section it would tantamount to crossing the boundaries of judicial review. So, my submission before your lordship is कि इसको easy नहीं लेना चाहिए कि legislature ने कोई चीज जानबूझ के छोड़ दी है. अब वो gap fill किस तरह करना है, that is where the doctrine of constitutional implication comes in, which is the next paragraph. Doctrine of constitutional implication. The next principle which we intend to discuss is the principle of constitutional implication. And to save time, my lord, I'll jump to the next page, page 23, third paragraph. There is no speck of doubt that the court has applied the doctrine of implication to expand the constitutional context, but the context in which the horizon has to be extracted has to be borne out in mind. What is suggested by Mr. Dwivedi is that by taking recourse to the said principles, the words employed in Article 71(1) are to be interpreted to add to add a stage in the disqualification, i.e. framing of charges in serious and heinous offences or offences relating to corruption. At this juncture, it is seemingly to state that the principle of implication is fundamentally founded on rational inference of an idea from the words used in the text. The concept of legitimate deduction is always recognized. In Melbourne Corporation versus Commonwealth, Dixon J. opinioned that constitutional implication should be based on considerations which are compelling. Mason CJ in political advertisement case has ruled that there can be structural implications which are logically or practically necessary for the preservation of the integrity of the structure. Any proposition that it arrived at taking this route of interpretation must find some resting pillar or strength on the basis of certain words in the text or scheme of the text. Now, to have constitutional implication by reading 62 and 63 all together, would I think...
Let's assume there is no Samiullah case. There is no section 230.
मैं ये 3 लाइनें पढ़
Then what is the literal interpretation of 62 and how you will disqualify the person?
तो मैं 3 पढ़ लूं?
जी.
In the words in the text.
Could you read Mason CJ से आगे?
Sir, ये 3 लाइनें बहुत important है. In the absence of that, it may not be permissible for a court to deduce any proposition as that would defeat the legitimacy of the reason. A proposition can be established by reading number of articles cohesively, for that will be in the domain of substantive legitimacy. Yes. Now this is the problem with the court. It recognizes there is a constitutional absence, it engages in the doctrine of constitutional implication, and then comes to the conclusion that there is only one implication possible without justifying it in terms of a overall reading of various interconnected articles, especially 63, especially 17. I think the reading of both is wrong. Now, अब सर अगर आप 62 1F पे मैं अगर आपको ले चलूं, after I have established the doctrinal basis of my argument, if your lordship may kindly see.
नहीं ये 62 जो गैप था ना, इसको किस तरह फिल करना है? मतलब आपने कहा ना कि
सर मेरा ये कहना है
62 1F के अंदर अगर समीउल्लाह भी ना हो और अभी ये 232 भी ना हो, तो अगर आम हालात में इसको पढ़ा जाता तो आप कैसे डिस्क्वालीफाई करते उसको? इलेक्शन टू इलेक्शन करते, 1 साल के लिए करते,
जरा से 62 1F पे आ जाए, मैं उसी वक्त एक्सप्लेन करता हूँ अगर मैं आ जाऊँ.
So are you saying that when there is a constitutional absence, it can only be filled by the legislature?
No, I'm saying if the court in the meanwhile fills it, it must be very conscious of the fact that since it's an absence left by the legislature, any interpretation which gives that absence a permanent character would be a violation of the constitutional absence which is left by the legislature.
Okay, now if there's a constitutional absence and the court fills it in, both the court and the legislature can do so.
Yes.
Correct?
Yes.
Which will prevail?
Legislature can't. Well,
one does this thing, the other does this thing.
Legislature can't as far as the constitution is.
Which will prevail then?
Sir, देखिए, मैं example के through quote करूँ.
जैसे भी आप करें.
If the court
both does it. हाँ. आज हमने एक इंटरप्रेट किया कोई चीज और आज ही हमें पता नहीं था, बराबर में पार्लियामेंट में एक लॉ बना दिया, हमें पता ही नहीं है, एक दूसरे को कुछ नहीं पता है. हमने भी वही काम कर दिया, उन्होंने भी वही काम कर दिया. मैं आपको who will prevail?
Concrete example देता हूँ जिसमें there will be no contradiction of prevailing. For example, अगर 1F को पढ़ा जाता, 62 1F को पढ़ा जाता, not as implying any kind of permanent disqualification, simply a disqualification which is about that election. It is a disqualification. He is unseated. Then that doesn't stop Parliament from doing anything regarding 1F. So it depends कि आप implication, but you have to take the silence very seriously. अगर आप आप लेंगे कि नहीं नहीं ये तो हमें इनवाइट किया है फॉर जुडिशियल
I've
एडवेंचर।
understood the point, but you have not answered the question that I
सर देखिए
posed.
अगर समीउल्लाह बलोच में ये लेट डाउन,
Forget the court.
अगर
I will take any other provision. Today we are interpreting something and simultaneously Parliament, we don't know what either of us are doing. They enact a law. Either one, they're contradictory. Which one will prevail?
Sir, I'll give you two examples.
Ji.
The Indian Supreme Court laid down detailed guidelines regarding the trafficking of women. But with trafficking of women, जिसके ऊपर कोई लॉ नहीं था,
ठीक.
तो उन्होंने लिख दिया अपनी जजमेंट में कि these guidelines will remain till the parliament passes a law.
वो तो
Recent
उन्हें लिख
example.
दिया ना, अगर लिखते ना for instance.
यही क्वेश्चन इसमें था, अगर समीउल्लाह में भी ये दिया जाता कि टिल द टाइम,
वो तो मसला ही हल हो गया फिर.
सर अगर लिख दिया जाता फिर तो कोई कॉन्ट्रडिक्शन ही नहीं होता। लेकिन मेरा मसला इस जजमेंट से और बुनियादी है। सर यू शुड स्टॉप दिस principle where all absences are filled in by the courts in a way that blocks the legitimate power of parliament. That cannot be.
How are you saying that? How do you say that the power of the parliament has been restricted by this judgment? The parliament can amend the constitution and bring about changes in Article 62.
Yes. Ultimately, it's not. Sir, constitutional amendment के through तो आप कुछ भी कर सकते हैं. But you have to understand that the reason why Parliament did not determine 63 में कर दिया, 62 में क्यों नहीं किया? इसलिए नहीं किया क्योंकि this they knew was a very delicate issue. They wanted to leave it indeterminate, so that future parliaments could decide on that through ordinary legislation also.
It's so delicate, why should we get into it if it's so delicate and so sensitive that the entire parliament in its collective wisdom was thinking it's so
चलिए,
sensitive?
आप चलें
And then
आगे.
7 of us
नहीं,
decide what it should be.
मेरे ख्याल
आगे बढ़ें.
Another implication of that would be that your lordships could leave it open, say that this 1F could only be implemented when parliament legislates on this, which parliament has now done in terms of section 232, that we will prescribe procedure, duration.
नहीं, क्योंकि हमने शुरू में, अगर आपको याद है, मैंने ये कई दफा पूछा था सवाल कि अगर हम कहें कि उस वक्त तो ये कानून था नहीं, तो वो अपनी जगह सही था समीउल्लाह बलोच. अब क्योंकि कानून आ गया है, अब कानून को फॉलो कर लें, तो दोनों रिकंसाइल नहीं हो जाएंगे.
So this will set another very dangerous precedent, that your courts will interpret constitutional provisions and pass judgments, and parliament can then get rid of all those judgments by simple legislation.
Okay.
This should never be allowed. This follows another very dangerous route.
चलें, जी, got it. आगे
जरा एक डॉक्ट्रिनल प्रिंसिपल जरा क्लियर कर दें.
जी, सर.
आप कह रहे हैं कि कॉन्स्टिट्यूशनल साइलेंस का जो प्रिंसिपल है वो ये है कि इफ देयर इज अ कॉन्स्टिट्यूशनल साइलेंस वी शुड रिस्पेक्ट एंड लीव इट देयर और वी मस्ट फिल इट. What's the principle?
The principle is that it has to be fulfilled through the doctrine of constitutional implication.
By the courts, through interpretational.
Yes, if it is required, if it's absolutely necessary. And such an implication should be taken.
Drawn from the whole constitution. So fair enough. So ये clear हो गया कि ideal would be the constitutional amendment, but the next possible thing that the court can do is to come up with a constitutional implication by looking at the constitution holistically, and you say that Samuel Baloch does not look at it holistically.
सर इतना obvious था कि अगर आप holistic view लेते, मैं सिर्फ ये आपने बार-बार, but it's worth looking at it
साहब
again.
वही again I will ask the question, आप
जी, सर.
बताएं कि इसको आम हालात में आप कैसे पढ़ेंगे, because the word declaration is used there.
Yes, मैं दो तरीके से इसको पढ़ूंगा. पहला तरीका मैंने बताया सर कि I would simply limit that declaration to the election which has happened. The second
Only
would
for the election.
Yes.
The first term,
Yeah.
during the period of that particular election,
Yes.
the disqualification will remain in
yes,
period.
yes. And
What about the declaration for that?
sir, declaration would be limited to that, जिस तरह RO reject करता है nominations. So वो declaration, sir.
You know, ये mutually destructive arguments है ना, somebody has argued that the RO has no right to declare.
नहीं मैं सिर्फ ये कह रहा हूँ उसका टाइम पीरियड वही होगा. मैं ये नहीं कह रहा कि वो रिजेक्ट, मैं कह रहा हूँ टाइम पीरियड वही होगा.
लेकिन होगा वो डिक्लेरेशन किताबें
सर डिक्लेरेशन के तहत
होगी और उसी पीरियड के लिए होगा.
जी.
और चूंकि ये डिस्क्वालिफिकेशन नहीं है, इट्स नॉट अ डिस्क्वालिफिकेशन. लेकिन डिस्क्वालिफिकेशन 63 में दिया गया।
सर इसके ऊपर डिबेट है कि ये क्वालिफिकेशन असल में ये प्रॉब्लम क्रिएट हुआ। अगर आप 1935 का एक्ट देखें गवर्नमेंट ऑफ इंडिया, उसमें ये दो चीजें नहीं थी, क्वालिफिकेशन
आप
डिस्क्वालिफिकेशन।
इतना दूर ना जाए, आप 85 से पहले देख लें, क्लियर था, कोई इशू नहीं था। 85
ये
के बाद
असल
करना
में
है।
शुरू होता है रियली 72 में, फिर 62 में, इंडियन कॉन्स्टिट्यूशन में भी है। नाउ 73
एक
में
फैसल साहब एक चीज बताइएगा कि ये जो कॉन्स्टिट्यूशनल इम्प्लीकेशंस है इस साइलेंस को हमने पुर करना है। नाउ दिस वुड डिपेंड फ्रॉम जजेस टू जजेस, दे वुड लुक एट समथिंग, दे विल टेक द कॉन्स्टिट्यूशन इन डायरेक्शन ए, एक और सेट ऑफ जजेस आएंगे जिस तरह अभी आपके सामने आ रहा है, दे विल टेक इट इन द डायरेक्शन बी। एज अ पॉलिसी, आई मीन वुड इट बी बेस्ट दैट कॉन्स्टिट्यूशनल साइलेंस बी लेफ्ट टू द पार्लियामेंट टू डिसाइड हाउ टू fill that constitutional silence rather than leaving it to a set of judges which might just play havoc with the
Sir,
silence?
I would say that silence should only be filled if it is absolutely necessary.
My lord is saying, why should it ever be filled?
No, it's absolutely necessary अगर उससे कोई constitutional problem create.
Why isn't the parliament realizing
Yes,
that?
no. मेरे ख्याल में one possible implication of this would be that this provision can only become executable. Sir, बहुत सारी provisions हैं जो implement नहीं हुआ। अगर आप article 212 देखें, there is since 73 and Justice Athar Minilla has pointed out, there is a provision to establish tribunal for tortious act by वो नहीं हुआ।
Officers,
तो एग्जीक्यूटिव एक्ट है ना,
नहीं नहीं, लेकिन नहीं हुआ। इसी तरीके से इंडियन सुप्रीम कोर्ट की जो इलेक्शन कमीशन की जजमेंट है, उन्होंने भी यही किया। उसमें यह था until there is a law which establishes how election commission is to be appointed, वो प्रेसिडेंट अपॉइंट करेगा। उन्होंने इन द मीनवाइल एक सिस्टम क्रिएट कर दिया जिसमें प्राइम मिनिस्टर, लीडर ऑफ द ऑपोजिशन, बट दे सेड this is until parliament passes a law. So this is also one of the possible constitutional implications.
You are saying if we incorporate the words, if this judgment Samiullah Baloch had simply written 3 more words till parliament legislates,
Yes.
this judgment would be okay.
This judgment, at least in terms of giving permanency to this constitutional absence, would be okay. Only to this, but I disagree with how 62.
You are saying वो आपको अलग मसले हैं उससे.
बहुत मसले हैं, क्योंकि सर 17 को
But
जिस तरह
whenever
पढ़ा-
you are saying as for future guidance for us,
सर ये बड़ा
we can then always should add the words, though there is a lacuna in the thing and we think there should be the thing. However, whenever parliament legislates, that will prevail, provided it is not violative of.
especially sir when it affects the foundations of democracy.
Got
That
it.
is very important. That is why this judgment should be set aside. Sir, in this country, democracy has been sabotaged through judicial murders, then through all other judicial acts.
अब आर्टिकल 17 की आप भी बात नहीं कर रहे हैं.
सर आर्टिकल 17 तो क्रिटिकल था, पहले 62, 63, अगर मैं 62, 63 की एक प्रोविजन की
आप बढ़ाएं, बताएं.
सर देखिएगा 62 1G देखिएगा सर, जरा लैंग्वेज देखिएगा सर, सिर्फ 1G. He has not, after the establishment of Pakistan, worked against the integrity of the constitution or opposed. Sir, 62(1)G.
Against the integrity of the country.
G.
How is the constitution?
Sorry, sir. He has not, although that should be used interchangeably, my lord. He has not, after the establishment of Pakistan, worked against the integrity of the country as opposed the ideology of Pakistan. Zara 63G देखिएगा.
जी वही चीज है.
He has been convicted by a court of competent jurisdiction for propagating any opinion or acting in any manner prejudicial to the ideology of Pakistan or the sovereignty, integrity or security of Pakistan or integrity or independence of the judiciary, or which defames or brings to ridicule the judiciary of the armed forces unless a period of 5 years has lapsed since this read. How can you not read these two provisions holistically? Sir,
एक सवाल आपसे पूछूं, it may be facetious, I don't know. What is the ideology of integrity? तो समझ आ जाता है. Ideology of Pakistan से आपका क्या मतलब है?
This will go into a long.
I mean, is it specified anywhere?
No, it's not.
That's all.
सर एक और आप जरा डेंजरस इम्प्लीकेशन देखें जो इंटरप्रिटेशन अडॉप्ट हुई है समीउल्लाह बलोच. इट ओनली फोकसेस ऑन एफ, बट व्हाट अबाउट डी एंड ई? डी और ई में तो आप किसी को लाइव डिस्क्वालीफाई कर देंगे और आपको डिक्लेरेशन बाय कोर्ट ऑफ लॉ की भी जरूरत नहीं है. जरा देखिए आप डी और ई, उसमें तो कोई सेफ गार्ड ही नहीं है. जी में आप किसी को लाइफ, अगर आपने यहाँ टाइम पीरियड को एज अ कॉन्स्टिट्यूशनल एब्सेंस नहीं पढ़ा तो एफ में तो एटलीस्ट उन्होंने
ये तो डी ई और एफ जी जो है ये तो enforceable ही नहीं ना. Who will determine that?
सर मैं कह रहा हूँ, लेकिन अगर आप
सिर्फ इसमें आया ना declaration of the
नहीं,
court.
लेकिन बात ये है सर, अगर आप इसमें टाइम पीरियड्स यूं कह दें कि ये तो disqualifications are for
आप
life.
ये कहना चाह रहे हैं ना कि जब समीउल्लाह वाला केस आर्ग्यू हो रहा था तो the court had an option to fill this silence.
Yes.
And they decided.
If it was absolutely
It was because people are contesting elections and they've been thrown out forever.
Yes.
What is to be done if there's a declaration to this effect? Are they going to miss that elections or all the future elections? So this was a case that had to be decided because elections are critical to democracy and
Yes.
we need to understand there's a right to contest under Article 17. तो फिर उन्होंने एक सोचा कि इसको लाइव कर दें और वो अगर देखते और सारी आपका आर्ग्यूमेंट है कि if they holistically they looked at the constitution they would have put some other meaning to it, and one easy meaning that you say comes to mind is that the person gets disqualified for that particular election and he gets on with life later on.
And there are two important principles which I've based it on. The first principle is that, sir, this court has to stop this intervention in terms of reading it. Reading is absolutely essential tool of interpretation, but should only be done when it's absolutely necessary, and it should only be done to the extent where you don't give a permanent character to your reading it. It's very important. The second is that one should be very careful when it comes to political parties, the foundations of democracy, leadership of political parties. Such interpretations should be avoided, which in any sense would be seen to derail democracy. That is why this notion of permanency, कि लोगों को political parties को permanently eliminate कर दो through judicial murders, through lifetime qualification, through criminal conviction, such interpretations should always be avoided by the court. And a minimalist intervention in terms of filling in constitutional
लोगों को मतलब भी पता थी क्या लिख रहे थे? I mean, उनको पता था sagacious का मतलब क्या होता है?
सर मैंने असल में
sagacious is a very ऊंचा टर्म है, उनको पता भी है इसका मतलब क्या है?
Sir,
Wise.
I
I mean, I don't know how, on what platform will this be tested.
Sir,
Are you sagacious? I would profess not to be sagacious unless I'm totally arrogant. I would say the two are contradictory.
Sir, I actually asked Raza Rabbani Saab, who is the architect of the 18th Amendment, why did you substitute 62(1)(f) and not restore the original provision? And he gave a very important answer. His answer was that, Faisal, we were dealing with over 100 amendments. And people, of course, from the religious parties as well as people who were center-right or right were not willing to support other amendments if this amendment was made and the original article was restored. So it was a compromise which was made. And a part of that compromise was that this absence was left. And the court should recognize this absence.
You say it was intentional.
Intentional. समीउल्लाह बलोच says नहीं, उसका मतलब ये है कि ये इंटेंशन है, और अगर कोई शख्स कोई और इंटरप्रिटेशन लेगा तो वो सेम नहीं है. My lord, that is not a humble way of interpreting.
यानी आपके कहने के मकसद ये कि एक मर्तबा 73 में कॉन्स्टिट्यूशन बना, उसमें परमानेंट डिस्क्वालिफिकेशन नहीं
सर उसमें तो सिर्फ 3 थी.
फिर उसके बाद 85 में अमेंडमेंट आई, उसमें भी परमानेंट नहीं थी, फिर 18th अमेंडमेंट आई, फिर परमानेंट नहीं की.
नहीं, 18th में भी परमानेंट थी. कब? ये तो कॉन्सेप्ट था ही नहीं.
तो इसका मतलब
I mean, just being a devil here, in the sense that if you were to look at 63 की जो punishments हैं, so somebody who commits a murder goes through a punishment, a period where there, there's redemption, and then he comes out, and then 5 years. So there's a process that he goes through, imprisonment of such a period of time, and then he maybe stands restored, reformed, and then there is 5 years. Either your declaration, I suppose the declaration is to the effect that he's a fraudster. Now, what happens? I mean, he's been declared a fraudster. There is no mechanism for his reformation. He's not being sent to any prison. He's not being sent to any facility. So he is a fraudster, and we say, come on, you can't go into the house because you're a fraudster. The other provisions have a mechanism of cleaning him up. You see, they send him to prison, he goes through a process and comes out clean. In this case, he doesn't. He just is declared a fraudster and left to his own whatever, best whatever. So the question is, don't you think there's a difference? Can we really import 63 into this? Or can we just say, are we actually saying when you say for this election, let him go? So we've declared him to be a fraudster, but then we said, okay, well, you're a fraudster just for this election, and without any process of his reforming himself, allow him to contest the election again. We certainly don't want fraudsters to come into the parliament ever again, unless they stand reformed. So there is no process of reformation, and that's why probably it's silent, because there is no process of cleaning him up or sending him through any sort of a reformative process which is available in 63. So what do we do? I mean, we're basically then saying that you're a fraudster, there is no process, go home, stay a fraudster, but contest the next election. How do we deal with that?
My lord, that is one of the...
I just want to, I had a question which now ties. Can you go to Samiullah Baloch, page 446, and what Justice Yahya had also drawn attention to? It is clear and obvious that the lack of qualification in terms of Article 60, declaration, etc., वो जो mechanism की जो बात कर रहे थे, sorry, वो कहाँ थी mechanism की? नहीं, sorry, that
35 में,
सिर्फ वो उससे पहले है
35 में, 35.
जी,
Judicial mechanism, ये किधर है judicial mechanism? Grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate himself. Where is this judicial mechanism?
I'll first answer that and I'll then connect it. Bilkul. Sir, your lordship has made two, with due respect, erroneous presumptions. And this is the argument which is given in Samiullah Baloch, which your lordship has expressed. The first is, sir, America has the biggest prison population. It is about 22 lakh people. 60 to 70% of the people who go to jail commit a crime within 2 years of coming out. There is no reformation.
I mean, I don't know, you might have friends there, but I don't.
So these are the statistics. Number two, sir, to denying an election to a politician, you think that is not?
Even though he was a fraudster?
No. Even he has acted against the integrity of Pakistan, security of Pakistan.
He's gone through a punishment of 10 years.
But he's allowed.
After having served the term.
Yes.
Well, all I'm saying is, I mean, I'm trying to find a solution. There is a declaration of the civil court saying you're a fraud. Not yourself, but the person who's contesting is a fraud. Now, he doesn't go through any mechanism of purging himself, and then we say, okay, we think you should just not contest this election, but you are still a fraud, contest the next one.
The reason why there is no conviction is because of different standards of proof in civil law and criminal law. You can be convicted, you can be...
No, you could have taken for this declaration in 62(1)(f), the Election Commission could have filed a complaint and could have taken him through the criminal process. They did not.
Yes, but...
So in one case, had they taken him, then 63H, 1H lag jata.
Yes.
Lekin nahi hua. So the only gap here is, what is the repentance, what's the purging of this person who has been declared to be a fraudulent person? How do we clean him up?
Do jawab hai. And then I'll connect the second question to his lordship's question. Sir, I think denying a politician the right to political activity is the greatest punishment to him. Politics is in their blood. Number two, and which is critically important, the people of Pakistan should judge whether they want to elect a fraudster or not. It is not for the court to decide on the people of Pakistan, on behalf of the people.
मैं आपको अपना जवाब देता हूँ.
ये बहुत बड़ी गलती हम करते हैं.
नहीं, मगर ये आप इस पे तो आ जाए ना, ये जजमेंट में मैंने जुडिशियल मैकेनिज्म to vindicate himself. ये कौन सा vindicate himself का mechanism है? ये जरा बताएं ना, ये जो paragraph 35 में जिक्र
Sir, Samiullah Baloch,
ये जो लफ्ज इस्तेमाल हुए हैं.
Samiullah Baloch doesn't deal with this.
He mentioned that he wants a
नहीं है,
mechanism.
मैंने
Yes.
आपको पहले पूछा ना उनसे.
It presumes that a judicial mechanism is there because this is a judgment. Should I
What
stop?
it means actually is that declaration through a court of law, you have a remedy to go get it fixed. You get the declaration set aside by a higher court.
Yes.
But if the final court of the land declares that and upholds that declaration, the story is over. So I think the vindication comes through the process of setting aside that declaration through a court of law.
Yes.
So वो vindication का तरीका है.
Sir, अब
जब मैं
देखिए-
आपको वैसे आपको इसका जो मेरे जहन में जो आ रही है बात, इसका सोल्यूशन इस्लाम में पाया जाता है. अब उधर भी कोई नहीं जाता है पाकिस्तान में, अनफॉर्चुनेटली. होली कुरान में क्या लिखा है? व्हाट आर ह्यूमन बीइंग्स? Human beings is the only of creation in which the Almighty has breathed his something of his spirit. That's the Holy Quran, Surah Sajda, verse 32, verses 6 and 7. So no person is per se bad. A person's acts are bad. No, try to understand this and it will resolve the issue. No person is per se bad, his actions are bad. I may be a drunkard, I may be whatever, womanizer today. Those are my acts. Tomorrow I stop doing those things. So that is the answer. So what the Almighty has prescribed, the status of a human being is very high. It's the only part of creation in which the Almighty has breathed His Spirit for those of us who are Muslims. So we have been placed at a very high pedestal. Our acts are bad, not ourselves are inherently bad. If you debar someone for life, you condemn that person for life. There is no redemption. There is no tawbah. Samiullah Baloch also touches upon in paragraph 6, tawbah, but doesn't attend to it at all. What happens? So tawbah is not something you come and profess and say, ji main to bada bacha ho gaya hu. And you may be lying through your teeth. It is something from within. So your act can be punished for a particular period, like the other acts are being punished, or any other punishment that is imposed. For theft, there is punishment. For whatever, every crime has certain limitations on punishments. It's not forever condemnation. And the minute the person itself cannot be condemned, no person can be condemned. So that door of mercy will remain open up there. And here, if you say, oh, you're a crook, now you're a crook for life, he stops being a crook. He becomes a very nice person, very honest person, starts helping people. Don't condemn him, condemn his acts. So why can't we draw this distinction between condemning a person's acts as opposed to condemning a person? 62(1)(f), Samiullah Baloch condemns not the act, condemns the person in perpetuity. Does it accord with Islamic injunctions?
It doesn't, and it doesn't accord with Article 62, 63. All punishments which are given in 63 are time-bound. How can a timeless punishment be added to 60? Sir, मुझे याद आता है आपने जो बात की, it's from a different source. Russian writer Dostoevsky वो कहता था कि you cannot be saved if you have not sinned, and you cannot be reborn if you have not been saved.
तो repentance तो कहीं लाए ना? Where is the evidence for repentance?
It is 63 आप पढ़े.
How do we know this person has repented?
That's it. In answer to my Lord's question, you just fix a time limit.
Sir,
whether he repents or not,
Sir,
we cannot
repentance
look
पे
into his
नहीं
heart.
है. जैसे his
अगर
lordship.
इस्लाम का concept है तौबा का है, so where is the evidence of this guy has
Sir,
fixed
the
himself?
point is that the issue is proportionate punishment, and that is the concept which is in 63. If I
That period alone
जैसे
would
ये आप कुछ और कहना चाहते हैं, आपने बड़ा interesting points दिए.
and actually I didn't want to repeat what others had argued.
No,
I
no,
just
don't. And we are really appreciate, at least I've learned a lot about this. I wasn't aware of this, the constitutional abeyance the doctrine of constitutional abeyance and absences, I must confess. So it's been educational. Any other point you want to bring on the table?
This is a very important, my last point. This is a very important check.
Get another one.
No. This is a very important check on this tendency to read things into the constitution. ये बहुत important check है sir, because at the end of the day, that should only be done if the constitutional framework has become unworkable.
You're telling us to read into it by
No,
saying
I'm not.
that election. That
No, अगर ये आपके सामने इशू उठता है और फिर ऐसी रीडिंग करें कि उसको परमानेंस ना दे, मैं सिर्फ ये कह रहा हूँ।
नहीं, आपके मुताबिक कैसे रीडिंग दें अभी?
सर वो तो मैंने बता दिया
क्या?
नेक्स्ट इलेक्शन।
Next election.
जी।
So this is you saying
Yes.
not.
And that will be. अब मैं आता हूँ, आपने, I was very confused on this issue of court of law, but after listening to your lordship's comments, now, that confusion has disappeared. Let me build on what your lordship talked about in interpreting court of law. Sir, एक दफा पढ़ लें उसको।
ये आपने नेक्स्ट इलेक्शन का बोला है, अभी डिक्लेरेशन कॉन्ट्ररी है उसके लिए।
नहीं, कम प्रेजेंट इलेक्शन।
62F में एक डिक्लेरेशन
प्रेजेंट इलेक्शन।
डिक्लेरेशन तो फिर भी
प्रेजेंट तो हो गया, खत्म हो गया ना।
सर, उसको
अब जब वो
DC
अगली दफा आएगा, जब नॉमिनेशन भरी जाएगी, तो वो जो चीज उसके अगेंस्ट होगी, तो क्या वो वैनिश हो चुकी होगी कि दैट वाज ओनली कन्फाइंड।
डिक्लेरेशन आ गई है, इस इलेक्शन में तो आपने डिस्क्वालीफाई कर दिया, नेक्स्ट के लिए होगी
नहीं सर, वो होगा ये कि मेरा व्यू ये है, मेरा व्यू ये है कि these declarations are to be made by the election tribunal. उसमें provisions मौजूद है to de-seat someone if he doesn't qualify.
ट्रिब्यूनल चले गए, वो तो यहाँ तो डिस्क्वालिफिकेशन जो है फॉर्म ही नहीं फिल हो रहा, तो
मेरे ख्याल में वो नहीं हो सकता. The only court of law. Now, that is why he will be de-seated for that election, my lord, for that term. But let me...
एग्जैक्ट जो है ना, आप उसका एग्जैक्ट आंसर दीजिए ना, ये इस चीज के ऊपर के इलेक्शन का जब फॉर्म भरा गया उसी वक्त रिजेक्ट हो गया वो. नाउ यू आर टॉकिंग अबाउट द ट्राइब्यूनल, देन द पर्सन विल गो टू द ट्राइब्यूनल एंड चैलेंज हिज कैंडिडेचर.
So that would not be the court of...
This is only at the time of filing nomination form, and if he is found guilty by any court and any adverse declaration is against him, he is out of the election.
No, my lord, this
is what the
pre-election, this declaration cannot, I don't want...
62 कैसे?
वो फिर उसका
62 होगा सर, 62 होगा जिस तरह one of the grounds on which an election can be declared as invalid.
No.
Person shall not be
60
qualified to.
नहीं सर, अगर आप देखिए
it is directly related to the qualification of contesting the election.
अगर आप देखिए 68 देखिए इलेक्शन एक्ट का सर,
62 देख लीजिए ना
सर, एक मिनट 68 देख लीजिए.
पहले 62 देख लीजिए. पर्सन शुड नॉट बी क्वालिफाइड टू बी इलेक्टेड, ये उसकी जो है कीवर्ड्स हैं इसके अंदर. फिर आप अगर एफ के साथ पढ़ेंगे, इफ इट इज टेकन इनटू कंसिडरेशन दैट इट इज ओनली वन टाइम एंड इवन इट इज टू बी लेफ्ट फॉर द ट्रिब्यूनल टू डिसाइड, देन देयर इज नो पर्सन.
नहीं सर, अगर आप 68 देखेंगे तो क्लियर हो जाएगा. Section 68 of the Election Act 2017. It's absolutely clear कि ये कब declaration given है. Grounds for declaring election of return candidates void.
नो रिटर्न का तो आप
सर एक मिनट मैं जरा पढ़ दूं सर, क्लियर हो जाएगा. मैं सेक्शन पढ़ दूं.
रिटर्न की तो बात ही नहीं हो रही ना
सर.
इलेक्शन एक्ट 2000.
जी. और इसी किस्म की प्रोविजन रोपा में थी सर.
अगर आप इसको 60 देखिए, अगर ये जो अल्फाज इस्तेमाल किए हुए हैं सेगेशियस और राइटियस, इसको क्या जुर्म के जुमरे में अप्लाएंगे?
सर मैं उस पे
अगर ये जराइम होंगे तो फिर आप इसको 63(1)(g) के साथ पढ़ लें.
सर मैं एक उसके वर्ड्स पे भी आता हूं. मैं पहले वो सेट कर दूं, 68 पढ़ दूं. आपका सवाल
जी. have seen that 68.
The tribunal shall declare the election of the returned candidate to be void if it is satisfied that B, the returned candidate was not on the nomination day qualified for or disqualified from being elected as a member. This is when the declaration comes in and he is de-seated.
अगला पॉइंट बताइए, समझ गए.
अब जो बात है, जो जस्टिस मंसूर अली शाह की बहुत इंपॉर्टेंट पॉइंट है सर, आई मस्ट बिल्ड ऑन दैट. What does 62(1)(f) say? What is it doing? और ये है कि इनके वर्ड्स का मीनिंग क्या है. Let us read this. He is sagacious, righteous, non-proliferate, honest, and ameen. Let us stop here. Where has this been determined? Who will determine this? What are the meaning of this? Pehla sawal. There being no declaration to the contrary by a court of law. Now, it doesn't tell us how these terms are to be defined. It simply tells us that there will be a declaration by a court of law. Now what 232 tries to do is try to solve these problems. It says कि इसमें जो absences हैं कि भाई ये जुर्म क्या होगा, इसके लिए अगर procedure नहीं है, चीजें नहीं है, तो that will be legislated on. It doesn't create a qualification itself unless there is some law which will really determine what this disqualification or qualification, whatever you want to call it, would be. Sir, court of law को jurisdiction कहाँ से आएगी? Some law will give its jurisdiction. Either there will be an amendment in the Election Act, like it has happened, which will determine कि court of law क्या होगा, वो court of law क्या standard of proof apply करेगा, इन words को किस तरह interpret करेगा. None of this is given in 62(1)(f). It simply says that these undefined terms will lead to a disqualification or qualification, whatever, by a court of law. Now, how that absences are to be fulfilled is for statutory framework to come.
इसमें आप ये कहना चाहते हैं, जो मैं समझाऊं, कि ये जो अल्फाज लिखे गए हैं
जी,
कि ये प्रिज्यूम किया जाएगा, जो भी कैंडिडेट आएगा वो प्रिज्यूम किया जाएगा कि वो सजेशन से है, राइटियस है, अमीन है, ऑनेस्ट है, मां सिवाय उस वक्त जब कोई डिक्लेरेशन आएगी, उसके अलावा कोई इसको नहीं कह सकता कि आप अमीन नहीं हो, आप सादिक
ना सिर्फ ये, मैं तो ये तक कहूंगा कि जब तक स्टैट्यूट ये स्पेसिफाई नहीं करता कि हाउ अ कोर्ट ऑफ लॉ विल डिटरमिन दीस टर्म्स,
फिर क्या करेंगे? जब तक ये डिटरमाइन नहीं होता फिर क्या करेंगे?
सर, लाइक अदर कॉन्स्टिट्यूशनल एब्सेंसेस, this will not be executable. What is the issue? There are a lot of provisions in the constitution which are not executed. इतनी सारी disqualification, सर, यहाँ politicians यही complain करते हैं कि 20 disqualifications हो गई हैं. क्या क्या disqualification नहीं है कि आपको ये add करने की जरूरत है? Completely undefined. Leave it to the statutory framework to determine the court of law, to determine the standard of proof, to determine what this term means.
We got the point.
My lord, the last.
Ji.
Bilkul. Sir, one clarification. There is no contradiction between Samiullah Baloch and the Faisal Wawda case.
There isn't.
No. If your
You're the
lordship
first person saying this.
No, my lord, it is obvious to me, and Justice Mansoor Ali Shah was of course part of that. If your lordship may look at the judgment, ये मखदूम साहब ने जो पेपर बुक दी है, इसमें आखिरी वाला टैब है 20 पे. ये
कहाँ है ये वाली?
बताएं.
वॉल्यूम 1A.
आखिरी वाला है अंदर.
1A.
किसने दी है?
Samiullah Baloch is erroneously decided, but there is no contradiction. Sir, if your lordship may see, ये tab 20 है and page 372.
जी.
Para 2. सर, इसके फैक्ट्स बहुत इंपॉर्टेंट है. वी हैव हर्ड द लर्नड. पैरा 2 में पढ़ रहा हूँ, पेज 370.
प्रिंसिपल बताइए ना.
सर, प्रिंसिपल ये है कि
डिस्क्वालीफाई हो गया.
सर, इलेक्शन कमीशन ने फैसल वाउडा को by exercising its powers under Article 218(3) disqualify कर दिया for a false affidavit. वो इस्लामाबाद हाई कोर्ट ने अपहेल्ड कर दी. अगर आप पैरा 3 पढ़ेंगे तो सुप्रीम कोर्ट has specified that that was not a declaration by a court of law and that judgment is set aside. That is why a permanent disqualification under Samiullah Baloch does not follow in para 4.
It was not a declaration
court is not
of
a
the
court of
court of law. The
No.
Election Commission conducted the inquiry and the finalized by the High Court.
Yes, and उन्होंने हाई कोर्ट
Court
की
was
जजमेंट
submitted in the High Court.
एंड उन्होंने हाई कोर्ट की जजमेंट सेट असाइड कर दी पैरा 3 में बाय सेइंग कि समीउल्लाह बलोच हैज बीन रॉन्गली अप्लाइड. इट्स नॉट अ
कहने
कोर्ट
से
ऑफ
तो कोई फर्क नहीं होगा ना.
नहीं, लेकिन सर कोर्ट ऑफ लॉ ही नहीं था.
हाई कोर्ट नहीं, कोर्ट ऑफ लॉ फिर क्या चीज?
नहीं, सेट असाइड कर दी जजमेंट.
आपके कहने
ये तो कोई बात नहीं हुई
सर
है.
अब मैं बता रहा हूँ
ये मेरी मतलब मेरी मर्जी में किसको डिस्क्वालीफाई करूं या जिसको ना करूं. नहीं, कोई लॉजिक बताइए ना इस बात में.
वो समीउल्लाह बलोच की लाइफ टाइम डिस्क्वालिफिकेशन अप्लाई करती अगर इस्लामाबाद हाई कोर्ट की जजमेंट सस्टेन होती एंड देयर वाज अ डिक्लेरेशन.
Professor Saab, ये तो
देयर इज नो
no. This is you're just begging the question. So suppose if Faisal Wabda's case would have been High Court judgment was upheld, you would say it's okay. If it's set aside, it's okay.
No, sir, if it was
What is the principle?
it was upheld because there was, that is why he was allowed to repent.
No, we are talking about the principle of law. Principle of law तो समझ आता है कि जी
Principle
ये
of
लाइफ
law
टाइम
तो
हो.
पैरा 4 पैरा 5 में कुछ नहीं मेरे ख्याल में माफ किया, लेकिन कॉन्ट्रडिक्शन नहीं है समीउल्लाह.
अब आप कॉन्ट्रडिक्शन
या
कर
तो
रहे
आप
हैं.
ये कह सकते हैं देखिए, या तो आप ये कह सकते हैं चूंकि इलेक्शन कमीशन को इख्तियार नहीं था, हाई कोर्ट उसी कंटिन्यूएशन में आते हुए तो हाई कोर्ट को भी हाई कोर्ट ने सिर्फ ये देखना था कि इलेक्शन कमीशन ने सही काम किया या गलत किया, तो उस कंटिन्यूएशन में हाई कोर्ट वाज नॉट एक्टिंग एज अ कोर्ट ऑफ लॉ.
जी
दो हाई कोर्ट इज अ कोर्ट ऑफ लॉ, बट एट दैट टाइम इट वाज नॉट वर्किंग एज अ कोर्ट ऑफ लॉ.
सर देखिए, मेरे ख्याल में जिस तरह सब गलती करते हैं और उनके ऊपर
I think you have just said this to placate Shah Saab.
नहीं. I would have loved to have said
I'm just
this.
on a
I would
lighter
have
note.
lied for his lordship, but this is not an. Sir, on a much more lighter, I think the Supreme Court has gone wrong in Samiullah Baloch. There's nothing wrong in admitted that. And to give your lordship's example, your lordship in a judgment of 2012, PLD 2012, Balochistan 1, in the Ubaidullah case, had also said that the disqualifications in Article 62 are in perpetuity. तो गलती सब करते हैं.
नहीं, हमें तो फॉलो करना होता है सुप्रीम कोर्ट को.
नहीं.
हम कैसे उसको कभी हमें जजमेंट पसंद नहीं आते फिर भी
सर
फॉलो
उस
करना
वक्त नहीं आया था, लेकिन ये चीजें हो जाती हैं.
हो जाती है.
कोई बात.
चलिए, गलती
सर, आई एम वेरी ग्रेटफुल.
I'm glad that you're taking a go at all of us.
सर मैंने बहुत शॉर्ट रखा है.
Then he didn't take a go at Shah Saab, he only took it at me.
अगर अभी क्लोज करें बजाय इसके क्या फर्दर किसी
मेरे ख्याल में आप घर जाइए.
There were a lot of other submissions, but I vote 6 o'clock.
We are most grateful
नहीं, sir.
to be provided such valuable
नहीं,
assistance at such a short notice.
Thank you, sir. Thank you.
अच्छा,
I'm
अब
very
कौन कौन रह गया हमारे सामने? एक तो मखदूम अली खान साहब ने कंक्लूड नहीं किया है ना. How long will you take? If you can just come here and tell us. If it's a few minutes or it's a few what?
My lord, it's entirely up to you.
No, it's entirely up to you. Provided we don't ask you too many questions, how long will you take?
I think within 20 to 30 minutes, my lord, maximum.
Okay, how long will you take?
Maximum 20 to 30, that's about.
Anybody else? Nobody left. आप किसके लिए आ गए?
In civil appeal numbers.
नहीं, ये छोड़ो ना, किस साइड पे हो आप?
My lord, in favor, not in favor of permanent disqualification.
वो तो काफी हो गया, अब कितना सुनेंगे?
But I just need to add for 5 minutes, only 2 things.
5 minutes ये हो गए. आप?
Sir, I am for the.
How long? How long?
Just 5 minutes.
5 minutes.
We're just counting the minutes.
We're just counting the minutes to see if we can do it today or not to do it.
लॉर्ड, अगर मुझे आप इजाजत दे देंगे इनसे पहले तो मैं आपको क्लियर कर दूंगा. इट्स अ सेपरेट इशू. 63(1)(a).
हम सुनेंगे ना, फिक्र ना करें.
ठीक है.
तो बाकी तो कोई नहीं है.
I'll take only 90 seconds.
आप किसके लिए हैं? इसके लिए हैं आप?
फिर मैं इस साइड पे पटिशन डिसाइड करूंगा.
वो इसी साइड पे
क्या चाहते हैं?
अच्छा,
नहीं होनी चाहिए.
अच्छा, आप किस लिए हैं कयूम साहब?
I'm supporting the law, my lord.
द लॉ, नॉट द जजमेंट. आप इम्प्लीमेंट वाले एप्लीकेशंस आपने फाइल किए हैं?
But appeal मेरी pending है जनाब के पास. The barrister forum was arguing in my appeal before, my lord.
You support the law.
ओके.
योर ऑनर, मैंने इम्प्लीमेंट की है और मैं
सर, अब जरा आपस में जरा पूछ लें.
वो तो उनकी थी ना. What about the Supreme Court Bar Association?
उनकी भी पिटीशन है.
आप कर रहे हैं बेस?
नहीं, सुप्रीम कोर्ट बार की भी थी ना कोई गूंज साहब की।
That petition, office objections were raised and it was chamber appeal which was fixed along with these appeals.
वो चाहते क्या उनका
So now President Supreme Court.
सैयद अली इमरान
सुप्रीम कोर्ट बार क्या चाहती है?
सर वो हमारी
आप क्या चाहते हैं, लाइफ टाइम या
नहीं सर विड्रॉ करना चाहते हैं जी, हमारी तो पिटीशन जो ऑब्जेक्शन
हम आपसे सुनना चाहते हैं
पॉइंट ऑफ व्यू क्या है
आपका
आपका?
पॉइंट ऑफ व्यू क्या है?
लाइफ टाइम बैन लॉ को सपोर्ट कर,
लॉ को करते हैं
लॉ सपोर्ट कर रहे हैं, ठीक है।
विड्रॉ क्यों करना चाहते हैं?
हमारी पिटीशन भी सर यही थी।
Chamber appeal थी।
चेंबर अपील में ऑब्जेक्शन है दैट वी कैन डील विद दैट।
ऑब्जेक्शंस हमने सारे ओवररूल कर दिए, आप समझ लें वो सब हो गए।
आई एम नॉट क्लियर, जरा ये आप आए, ये सुप्रीम कोर्ट बार की कंटेंशन क्या है? आप क्या कहते हैं?
लॉर्डशिप हम सपोर्ट द लॉ करते हैं, हमने यही पिटीशन हमारी यही थी सर कि जो
टाइम पीरियड दिया गया है लॉ में वो आप कर रहे हैं?
करने का क्या वो सर हम यही कहते हैं कि 5 साल होना चाहिए सर, जो
5 साल।
जी सर नहीं वो है हमारा
आपकी फिर बाकी इशू हम डिसाइड कर लेंगे, तो 184(3) तो हम इन्वोक नहीं कर रहे हैं, हम तो वो अपील्स में आए हैं, ठीक है। चलो हम देख लेते हैं, तो आप कंसेंसस में जरा पूछ लो अपने साथियों से, इफ दे वांट टू कंटिन्यू और नॉट। इसका फायदा ये होता है एट द एंड ऑफ द डे आप लोग भी थके होते, कम बात करोगे।
Let's start in
वो जो 5 मिनट वाले वो पहले खत्म कर लें।
मेरी
आपकी 5 मिनट स्टार्ट्स नाउ।
Sir, my client took a very principled stance.
लॉर्डशिप ठीक है, मसला हल करें। नहीं क्या है उनसे छुट्टी की बात करें उसको मुश्किल
फिर हम लोग कल पे कर लेते हैं, टुमारो।
वो 11:30 है, we can start for today tomorrow उसको चेंज करना।
The tribunals at the high courts have started functioning.
नहीं वो छोड़े बातें, हम सिर्फ
That's till the 10th.
Yes.
So we have till the 10th.
तो हम कल नहीं, उससे पहले
कल अगर कर ले तो
ठीक है।
कल
तो we will start, can we start
9:30 अगर
can we start at 9 o'clock?
Absolutely,
You can start at 8:30 if you like.
No, 9 o'clock इसलिए कर लेते हैं, कल हमने रेफरेंस भी रखा है गजाली साहब का, तो 9 o'clock हम शुरू करें।
9 o'clock
Whoever is here will
here at
start
6 a.m. We'll start at 9, but you be here at 6 a.m. You're really fond of coming.
So I can be here.
अच्छा चलिए, तो आप उन लोगों को बुला लें। आप कुछ बहुत बेताब हो रहे हैं, अगर 2-4 बातें करना चाहें कर लें।
नहीं सर, मैं कल ही
आपको जाना है लाहौर, तो बता दें।
नहीं सर, मैं I'll stay here. I just wanted to emphasize that my client took a very principled stance, being a firm believer of parliamentary supremacy and civilian supremacy. और उसने 62
So you are supporting the law, supporting the
मैं तो सपोर्ट कर रहा हूँ माय लॉर्ड, बट मेरा जो अपील है मेरिट्स पे, उसमें इशू थोड़ा सा डिफरेंट है। वो
क्या है इशू आपका?
माय लॉर्ड, हाई कोर्ट ने एक इनक्रेडिबल फाइंडिंग दी है।
लंबी बात ना करें, छोटी बात।
उन्होंने ये कहा है माय लॉर्ड, उन्होंने बेसिकली रिडंडेंट कर दिया 63(1)(h) को, जो कहता है कि 5 years के लिए डिस्क्वालिफिकेशन रहती है फॉर अ पर्सन हु हैज बीन कन्विक्टेड बाय अ कॉम्पिटेंट कोर्ट। So मेरे केस में there was a conviction by a trial court जिसके अंदर 2 साल की सजा हो गई। नॉमिनेशन पेपर उन्होंने फाइल किए, आरओ ने रिजेक्ट कर दिया बिकॉज ऑफ द कन्विक्शन, और वो सजा पूरी 5 साल नहीं हुई थी, लैप्स नहीं हुआ था।
कर दिया फिर
अब
हाई कोर्ट ने क्या किया?
हाई कोर्ट ने कंफर्म किया, रिजेक्टेड ही रखे, उन्होंने रिट फाइल कर दी। डिवीजन बेंच ऑफ द हाई कोर्ट ने कहा क्योंकि उसने एक अपील फाइल कर दी है, देयरफॉर द डिस्क्वालिफिकेशन इज गॉन।
अच्छा, pendency of the appeal.
Pendency of the appeal. My lord, this is-
आप तो चाह रहे हैं कि डिस्क्वालिफिकेशन आपका क्लाइंट, अच्छा आप कह रहे हैं सिर्फ
63(1)(h) की डिस्क्वालिफिकेशन।
अच्छा ओके ठीक है, तो वो तो फिर हो जाएगा।
जजमेंट सिर्फ मैं चाहता हूँ सेटिसाइड हो जाए माय लॉर्ड, उसमें
आपकी कौन से इलेक्शन का था, इस मौजूदा इलेक्शन?
माय लॉर्ड लास्ट टाइम का था, बट अपील अभी तक उनकी पेंडिंग है, और ये जो एक बुनियादी प्रिंसिपल है क्रिमिनल लॉ का कि जब
उसके मुखालिफ
ऑपरेशन सस्पेंड किया है क्या उन्होंने ट्रायल कोर्ट का?
उन्होंने कहा कि जी ये डिस्क्वालिफिकेशन नहीं है, ही कैन कंटेस्ट द इलेक्शन, रिडंडेंट कर दिया 63(1)(h).
Last elections was there in 2018. He was not allowed, and thereafter the matter
My lord,
is now subject. It's
मैं कल सुबह को पढ़ना चाहूंगा वो जजमेंट का पैराग्राफ, तो आपको क्लियर हो जाएगा कि what has been done by the court.
मैटर इंफ्रक्चर्स हो चुके हैं माय लॉर्ड, इलेक्शन मैटर में आए।
सस्पेंड हो गई थी, कन्विक्शन तो नहीं सेटिसाइड हुई।
सस्पेंड हुई नहीं माय लॉर्ड, हुई नहीं, सिर्फ सेंटेंस सस्पेंड हुई है बहुत पहले, नॉट कन्विक्शन।
सर हमारा भी इसी तरह का इशू है।
मगर वो जो बाकी बोर्ड हम कर नहीं सकते ना, तो कमेटी ना करे। ठीक है, थैंक यू एवरीवन।
184 की
9 o'clock, 9 o'clock tomorrow, not 9:30।
छोटी सी रिक्वेस्ट करना थी सर, हमारे नॉमिनेशन पेपर्स फाइल हुए, उसके ऊपर कोई ऑब्जेक्शन नहीं आए, नॉमिनेशन पेपर्स एक्सेप्ट हो गए। सब्सिक्वेंटली योर ऑनर दे हैव फाइल्ड एन अपील बिफोर, दैट इज
तो लोगों की राइट है।
हाँ, दैट इज सब्जुडिस बिफोर।
हम वो नहीं छुएंगे, हम सिर्फ असूल तयन कर देंगे कि 232 अप्लाई कर रहा है, नहीं कर रहा है, समीला बलोच का नहीं, बाकी हम नहीं कुछ छुएंगे ना। आपकी राइट ऑफ अपील खत्म करेंगे ना दूसरी साइड जो आपके खिलाफ है उसकी, हम उस पर कुछ नजरअंदाज नहीं होंगे। वो ट्राइब्यूनल्स अपना काम करेंगे। द ओनली थिंग इज दे विल बी हैव क्लैरिटी फ्रॉम टुमारो और डे आफ्टर व्हेनेवर।
सर वो हमारी सस्पेंड है।
ठीक है, वो
I may be excused for tomorrow, sir.
No, you, thank you very much. Yes, you've concluded. Thank you.
इस वक्त उम्मत पर बुरे हालात हैं। 57 मुल्क सारे, सिर्फ फ़लस्तीन नहीं, सिर्फ गज़ा नहीं, पूरी उम्मत बुरे हालात का शिकार है। बुरे हुक्मरान हैं, निकम्मे हुक्मरान हैं, बुज़दिल हुक्मरान हैं, मौत से डरते हैं। मेरे नबी ने फरमाया था, एक दिन आएगा कि उम्मतें तुम्हें ऐसे तकसीम करेंगी जैसे खाना तकसीम किया जाता है। वो 300 साल से ज़िल्लत की चक्की में पिस रहे हैं, पिस रहे हैं, पिस रहे हैं, पिस रहे हैं। लेकिन ये हालात, मेरे नबी ने फरमाया, मेरी उम्मत पे आखिरत में बड़ा अजाब नहीं है, मेरी उम्मत का अजाब दुनिया में ही हो जाएगा। कहा ये वो क्या है? का वो कत्ल है। इनका कत्ल होना इनके गुनाह की माफ़ी का ज़रिया बन जाएगा। अल्लाह दुश्मन के दिलों से तुम्हारा रोब निकाल देगा। अल्लाह दुश्मन के दिलों से तुम्हारा रोब निकाल। खालिद का नाम सुनकर रोम कांप उठता था। अल्लाह तुम्हारे दिलों में वहन डाल देगा। आपने फरमाया, दुनिया से प्यार करोगे और मौत से डरोगे, मौत को बुरा समझोगे। और जो अर्ज़ फ़लस्तीन है, अल्लाह इसे ज़ाय नहीं करेगा। आपने कहा अर्ज़ुल मंशर वल महशर, ये वो ज़मीन है जहाँ पर हशर कायम होगा। कनाडा में एक नौजवान ख्वाब देख रहा है, राविंड का पढ़ा हुआ आलिम है, कि मैंने ख्वाब देखा कि गज़ा के शुहदा के बच्चे आसमान पर तैर रहे हैं और अल्लाह के नबी हर आने वाले बच्चे का इस्तकबाल फरमा रहे हैं। वल अर्द बाद ज़ालिका दहाहा, वो बिछती चली गई। आसमान को हुक्म दिया तो वो बुलंद हो गया। रफ़ा समा बग़ैर अमदिन तरौनहा, बादलों को हुक्म दिया तो देखो आज वो आसमान पे छाए